Welcome everyone to today's webinar. My name is Heather Stone. I'm the executive editor of the Habitat Group. We publish the monthly New York Apartment Law Insider and the annual Apartment Management Checklist and the annual Rent Regulation Checklist. And the author is with us here today, Eileen O'Toole. Before I introduce her, I would like to thank Anthony Kazazis of the New York City Real Estate Group for inviting us to present at today's expo. So Eileen is the principal of the law office of Eileen O'Toole. She counsels owners, lenders, and prospective purchasers of residential properties on rent regulatory and other housing issues. She also appears before the courts and DHCR in all phases of landlord-tenant litigation. Thank you for joining us, Eileen.
Thank you, Heather, and thank you, Anthony and Julie and everyone involved with putting the expo together.
Yes, and the 2021 edition of your book, The Rent Regulation Checklist, is out this week, hot off the presses. And I know a lot has been going on in the past year, not just with COVID-related things, but rent regulatory issues are being decided in the courts, and you're here to tell us all about that.
Okay, so, and we will have some, a slide deck to go with what we're talking about as we get going here, so that—
Yes, I'm gonna launch that right now, if you bear with me 1 second.
Okay, so as Heather indicated, a lot has happened, even though businesses were certainly slowed down. The DHCR was closed for several months between March and June. The courts were slowed down significantly at the beginning of the COVID pandemic and continue to operate with a backlog given the eviction moratorium. What I'll show you here in our first slide is just a little overview of what I'm going to try to cover today. We have some time with a half an hour, but it's a lot to cover. So probably some of the details in the slides I won't necessarily talk about, but you'll have the slides to refer to kind of the bullet points of what has happened with HSTPA. And since—
Yes, we'll send everyone a copy of the slides after the presentation.
Okay, great. So you'll see here a list of the topics I'm going to try to cover, and at the end I'll give you some information for how to stay informed on different topics. And one thing I'll throw out at the outset here, just my general disclaimer, this is an educational seminar. It's not meant as specific legal advice on any of these topics, and that's particularly so because there just are a lot of variations on the themes in what's happening, and a lot of individual results in different cases, and a lot of things are very fact specific in this area of law. So I'm going to highlight what changed with the HSTPA and talk about what's gone on in the past year during the COVID pandemic, because more than I expected, there has been some amount of case law on a lot of these topics. So the first thing I'll talk about is deregulation. And there, as people may know, I'm not sure who's out there today watching this, under rent stabilization and rent control, there have been two types of deregulation, and they both have to do with rents reaching a certain level, initially $2,000 a month, and then the levels went up for a while. So you had vacancy deregulation that occurred when an apartment became vacant and you added on different rent increases the owner was entitled to upon vacancy, and if the rent got over the threshold, you were deregulated. Then there was high rent, high income deregulation, which involved, rents reaching the threshold and tenant incomes being at a certain level that resulted if the owners filed applications that were approved by DHCR in deregulation. Both of those were repealed as of June 14th, 2019. And the law said that any apartments lawfully deregulated before June 4th, 2019 remain deregulated. Now that continues to raise some questions because even if an apartment was vacancy deregulated long before 2019, a tenant can still challenge whether the apartment was properly deregulated, and an owner will have to prove that if it's an issue in court or a DHCR proceeding. What there has been more activity in since HSTPA and through the COVID pandemic period are these high rent, high income deregulation applications. These were on an annual cycle. When the 2019 cycle started, just before HSTPA went into effect, a lot of applications had been filed. And after HSTPA, DHCR began dismissing those because since there was no more deregulation, they said they couldn't process them because you couldn't deregulate apartments anymore. So a lot of owners challenged those. There have been a lot of PARs, the administrative appeals of those applications. They've been dismissed on the 2019 applications because there just is no more high rent, high income deregulations. There have been a lot of PAR decisions denying those, appeals of those decisions, and even from prior cycles that the DHCR had never decided until, after HSTPA. So those have worked their way up. There have been some court decisions on these now. And one of the things that happened, if an owner got an order of deregulation from the rent administrator before June 14th, 2019, these orders, and this was always true, it wasn't something that came with HSTPA, if the orders would say the apartment will be deregulated at the end of the current lease term. So you could have an order issued on June 1st, 2019 saying the apartment is deregulated, but several months later, after HSTPA, DHCR was issuing these explanatory addenda orders saying that, what that means is since there's no more deregulation, you're not deregulated because the apartment is still under rent stabilization. And when this lease expires, there's no more deregulation to go to. So there have been, I gave here a sample of the language that's in one of those orders. We can go to the next slide, Heather. And what has happened is a lot of owners appealed these explanatory addenda orders. There have been many PAR decisions denying those applications, and they have started working their way up to court appeals. And I cited at least one court decision that denied that issue for the owner. Owners may continue to file some appeals of these. I don't know that there will be much success with that since the law that ended up with this result was in effect before HSTPA was enacted. So there may still be some appeals or further appeals of this issue, but I'm not sure where it might go. So the next thing I'll talk about is leasing issues. And one of the big things that happened with HSTPA was the elimination of a lot of rent increases upon vacancies. There used to be 20% vacancy increase with a new lease for a 2-year lease. It was a little less than that if the tenant had a 1-year lease. And those were done away with. It was a little unclear initially whether owners could even be taking renewal leases with vacancy leases, although DHCR and the Rent Guidelines Board has indicated that you can. One of the things I think was the first time I've seen this, every year there are still annual rent guidelines issued by DHCR, or not DHCR, the Rent Guidelines Board. And you had one amount for a 1-year lease and a different amount for a 2-year lease. But what they did this year was for a 1-year lease, there's a 0% increase. For a 2-year lease, they give 0% for the first year and 1% for the second year. That's something I had not seen before, and that's been a little different. So a lot of the previously permitted additional increases are also gone. We could move to the next slide, still talking about leasing issues. One of the things I'll mention here is that one of the things in HSTPA talks about mitigation of damages. It codifies an owner's obligation to mitigate damages if a tenant breaks a lease. Previously, there had been case law on that issue. The courts in Brooklyn might go a different way than the courts in Manhattan, and the law on that issue changed periodically. But now the landlord has the duty to mitigate damages. And one of the things that was happening a lot at the beginning of the COVID pandemic, I think it's tapered off at this point. You had a number of both rent regulated and unregulated tenants seeking to move out and break their leases. And that actually presented the opportunity for a lot of landlords and tenants to work out issues that they had. And, various things got rebuffed. Sometimes when the tenant broke the lease and maybe hadn't been paying rent, if there was an overcharge complaint, that got resolved as part of this. Different issues. It did offer an opportunity for resolution of a lot of issues in different situations. One thing I will mention on leasing, the last thing I'll mention on leasing, is that this is not specifically an HSTPA issue, but in 2019, there was a good cause eviction bill pending in Albany that a lot of owners were concerned about because it was going to require renewal of leases of unregulated tenants unless there was good cause not to. After COVID hit and there were so many available apartments and so many tenants not renewing leases and so many questions about whether rents should be reduced anyway, the push for that died down for a while. But I understand there are active bills in Albany again on this issue, so that's something people may want to keep an eye on. And the only other thing I'll mention about leases is sometimes they're rent stabilized, sometimes they have to do with other city laws. Every year there are more and more riders issued by DHCR and other government entities that need to be attached to both rent stabilized and unregulated residential leases. Moving on, rent overcharge. Rent overcharge, I'll try not to talk too long on this, but there's a lot to talk about. The big thing in HSTPA was changing the 4-year statute of limitations on overcharge to 6 years and increasing the period that tenants could get treble damages for. And the law specifically applied the 6-year statute of limitations retroactively. So if there were pending complaints, and there were a lot of them in June of 2019, suddenly the 6-year look back period was applied. So even there was a whole period of a lot of back and forth where DHCR was asking people to supplement answers to overcharge complaints, going back another 2 years after going back 4 years with documentation. If a decision was issued and a PAR was filed by the tenant or the owner, DHCR was reopening the cases to send them back to apply the 6-year rule under HSTPA. And owners were appealing those and objecting to those. And, the issue was even coming up in the courts and applying HSTPA retroactively. But then about a year ago, at the beginning of April of 2020, the issue got quickly up to the Court of Appeals, and the Court of Appeals decided in the case of Regina versus, I know we're ahead on the next slide, Regina Metropolitan Company versus DHCR, that changing the statute of limitations on overcharges in pending cases that were pending in June of 2019, was a denial of due process to owners. So that they basically struck down that portion of the law. So that resulted in DHCR and courts flipping back again on how they were going to decide the cases. DHCR reopened various things that had gone one way on. They're still working through those cases. The courts have tended to act a little faster just because even though things are slowed down there too, they move a little faster. And some of the courts were even applying Regina on their own while everything was shut down, rather than waiting for people to make motions on it. But what specifically is happening now as a result of Regina is still starting to filter out in the case law. because one of the things Regina did was say specifically that instead of applying default formulas, you have to use what the rent was that was charged 4 years before the overcharge complaint was filed and build it up from there to figure out what the overcharge, if any, is. So procedurally, it's been very messy. Every case seems to have a different set of facts and raise different issues. And there still may be more things that come up in relation to that, but Regina clarified a lot of things in a big way. So I think now we're even running through a little on the slides here. There's the next slide, Heather, I think we've kind of covered. And then if you go to the last slide on rent overcharges, yeah, I've covered that. And maybe we go to the next slide. There's just a few things, a few other points on rent overcharge. All these changes about going back 6 years have to do with rent stabilization. They don't apply to rent control. You have a lot fewer complaints about overcharges with rent control, but it's a shorter statute of limitations, and tenants have to go to court to file a judgment to recover on overcharges under rent control. So that's a little different. One thing I'll mention, and I think I'm going to be doing a little article on this for ALI. The HSTPA said, DHCR has to award attorney's fees if they're requested in proceedings. That was always a discretionary thing. And there were 2-part decisions in the last month or so. I think they're reported in the LVT monthly case digest that I write for Habitat, that the tenant's attorneys sought attorney's fees in the DHCR proceeding. DHCR awarded attorney's fees, and they actually even talked about the hourly rate that they would award. The attorneys in these 2 cases were experienced attorneys in this particular field, and in both of the cases, they may have asked for a little more than this, but DHCR said that, okay, $4.25 an hour is, we believe, a reasonable rate to be applying for overcharge, for attorney's fees in a rent overcharge case. The other big case that went up to the Court of Appeals at the same time as Regina was Collazo versus Netherland Properties. That had to do with something that was also changed in HSTPA, that tenants have the choice of forum. So if tenants decide to file their overcharge complaint in court rather than DHCR, the courts can't say, this is really something DHCR decides, throwing up their hands and the prospect of calculating rent overcharges and basically punting the cases to DHCR. Courts can't do that now, because the HSTPA said you can't do that, and the issue went up to the Court of Appeals, who said you can't do that. So that's rent overcharge in a nutshell, although this has been a big issue in the past year and a half, and there continues to be, when we see DHCR issuing decisions on PARs in the last year or so, it seems like half the decisions that come out of DHCR, if not more, have to do with rent overcharge issues, because there's so many cases. Okay, individual apartment improvements. I won't go into the details about that. We've talked about this before. You've seen things before. IAI increases have become temporary, not permanent. What owners can collect on IAI rent increases has been substantially reduced and makes it difficult for owners to recover what they may have to spend on individual apartment improvements in a vacancy. And this IAIs are a frequent issue that come up in rent overcharge complaints. Tenants will often say what was charged for them was excessive or can't be substantiated, or that no improvements were done, period. Owners are left with having to prove their IAIs sometimes long after the fact, because now even if you have an apartment that was vacancy deregulated some time ago, the 6-year statute of limitations now isn't what even applies. You have to go back to the point of deregulation and prove how an apartment got deregulated. And sometimes that could be 15 or 20 years ago. So it's important for owners to hold on to documentation. indefinitely, and it's important to think about what forms of proof you may have if the most obvious form is not available at this point. So, oh, one thing also, HSTPA required DHCR, and they have done this, to set up a centralized electronic reporting and recording system for individual apartment improvement information. It's kind of tied in with rent registration, but owners now have to file the information on how they have increased rents through IAIs with the DHCR. That's new, and that is something that has to be done through an online service that's part of what DHCR has on their website.
That's all set up now?
Yes, that was actually set up. It was set up sometime last year. Yes, so that is actually all set up at this point. Okay, MCIs. Trying to move along here because I want to talk a little bit about non-payments. MCIs also, the increases are substantially cut. They are made temporary instead of permanent. And one thing HSTPA required DHCR to do that they also have gotten around to doing is to set up a reasonable cost schedule. So a reasonable cost schedule is now applicable, and if your MCI costs exceed that, DHCR generally won't allow you to collect on MCIs that cost more than what they say is the reasonable cost. Although one thing, and they're doing the reasonable cost schedule annually, so they've issued 2 of them already since HSTPA came out. One came out last summer, and they issued another one at the beginning of this year. And one thing that DHCR did provide was that the reasonable cost schedule is not being applied retroactively. It's prospective from when they came out, so they don't have so much of a Regina retroactivity issue on that. And the other thing is, like, they are allowing for owners to submit some kind of waiver request. How that works and how often someone may actually qualify to get the waiver of the reasonable cost schedule remains to be seen. There probably will end up being case law on that, although I haven't seen any yet. MCI. Oh, one of the things HSTPA also directed DHCR to do was to issue rent stabilization code amendments, that's regulatory amendments, to go with the changes in the law. And DHCR was directed to do that by June of 2020. So far, they have not done that. And the only thing they have set up some policies and procedures on that would probably be the basis of rent stabilization code amendments has to do with the area of MCIs, and that the information on what they have proposed or put into effect on that is on DHCR's website. Okay, co-ops and condos, I'm not going to talk about. It just has made it harder to do a co-op and condo conversion under HSTPA. And I do want to talk a little bit about non-payment proceedings because that is such a big issue, and it goes a little bit beyond HSTPA, but in some ways it starts with that. HSTPA, to a lot of people's surprise, didn't just focus on rent stabilization and rent control laws. It amended the real property law and real property actions and proceedings law to just require more notices about rent payment. There was a rent reminder notice that had to be issued before the rent demand, and the periods for responding to petitions in housing court were made longer. It became a little harder to get eviction warrants, and that was all pre-COVID. And then what happened once COVID hit is that first through executive orders from the governor's office, and then there have been a few statutes in New York, we have the eviction moratorium laws. And right now, the eviction moratorium is in effect in New York until May 1st. There's a separate one for commercial tenancies, but this is the one we're focused on here for residential tenancies. And Whether or not that gets extended remains to be seen. You know, the law, they've been extended several times. I'm going to give you a couple of website references at the end of the talk on the slides here, where you can, you know, check in between the court websites and the DHCR websites just to keep track of changes. The court website in particular has been good about issuing a little talk every Monday from Judge Fiore about what's happening in the courts and what's happening with the eviction moratoria. The courts have gone virtual for a lot of things. A lot of what happens in court today, in housing court, and has to do with has to do with just keeping as much virtual as possible. And a lot of that has been happening. They have started to have some live jury trials again. And the court system's been very careful about following the COVID numbers, and they were about to go live with jury trials and then cut it back because, you know, the COVID numbers were up, and the number, you know, while judges are working, the court staff was cut down to about 30% of staff people who are actually in the courthouses because of COVID. So even though, you know, on top of having the eviction moratorium, which is preventing most evictions from going forward at this point, the court system is so backed up that it's just gotten very slow. And while initially I think commercial non-payments were a much bigger problem than residential non-payments, residential non-payments may have caught up somewhat. And what has been happening, I think that owners and tenants to some extent have been trying to address issues and see what can be worked out. The law that came into effect in December, the emergency, if we go to the next slide, I think I have the name of the law here. The COVID Emergency Eviction and Foreclosure Act of 2020.
There we go.
Oh, you got it. Okay, that extended the eviction moratorium, and also it extended the eviction moratorium, and it also provided for tenants to present a hardship declaration that would delay evictions again. But one of the things is that the owners have been made responsible for sending the tenants the forms for this whenever they send any of the preliminary notices or court petitions. So a lot of the onus is on the owners. The other thing that's significant that's happened, there is yet a new rent relief bill that's coming through, if it didn't go through already within the past week. And owners and tenants can apply for the money under that. The money goes to the landlords. There are some restrictions that go with it, and if the owners don't accept it, there may be a negative inference if they're then suing to evict the tenants for non-payment. We are probably getting close to not having much time. Just on holdovers, the one thing I'll mention is that the Regina logic of certain things being applied retroactively is unfair to owners was now applied in an owner occupancy case. This Harris versus Israel case that I've cited here and given you the site, that's significant. That decision just came out in the last month or so. And going to the end here, if we go to the last slide on staying informed, the two things I'll point out, the DHCR webpage keeps you up on what DHCR is doing, and the Unified Court System webpage keeps you up on what's going on with the eviction moratoriums. So that's about it. I know there's a lot of information here, but I appreciate you all listening, and thank you very much, Anthony and Heather.
Okay, well, thank you very much, Eileen. And I'm sorry, I'm getting the wrong screen up.
We're getting the cane.
Yeah. Here we go. Okay, well, thank you so much, Eileen. Thank you, Anthony, and thank you everyone for attending. We will be sending a copy of the slides to everyone.
I want to thank, definitely. Thank you, Eileen. Thank you, Heather. It's such a great, a great webinar. And I just want to let the audience know that, we're going to be working alongside with Habitat and Eileen to bring you more of these. And so we're looking forward to that. We'll be back actually in about 10 more minutes. And our next presentation will be how DMG Investment is putting its 700 million AUM to work in the current marketplace. But I once again want to thank everybody and conclude this webinar. Thank you.
Okay, thank you.
Bye-bye, everybody.
Bye-bye.